On February 12, 2026, in Bexar County, Texas, a family court judge presided over case number 25 VLOF 352719, a termination of parent-child relationship proceeding involving two children. The case features Demetrius Flores as the non-custodial parent and Courtney Johnson as the custodial parent, with a central dispute revolving around attorney ad litem fees and whether indigent parties can be compelled to pay for court-appointed legal representation for their children. The hearing addresses the financial obligations for Ms. Cusack, who serves as attorney ad litem for the children, and whether the county or the parents themselves must bear these costs.
Time, we're on the record, and this is Bell County Calls number 25, DFAM 352,719. This is in the interest of Flores minor children. Non-custodial party is Demetrius Flores. Custodial party is Courtney Johnson. And this matters before the court on a written petition seeking affecting parent-child relationship involving two children. The court will take judicial notice of the court file. Note for the record that both parties have previously been noticed and served that we've been operating under at least one temporary order. Looks like since September of 2025, they may get a second one here. Kind of thick, so. Anyway, there is a temporary order in effect in this matter. Court will note for the record, Ms. Cusack is present. She was appointed, Ms. Cusack, were you appointed as guardian ad litem or attorney ad litem?
I think originally it was in the as guardian and attorney ad litem, and then that was part of the de novo process. And I
Right.
think
So,
landed
district
as
judge changed it to
attorney
and the district judge changed it to guardian.
to the judge did change it to guardian ad litem, and then at the last hearing, the motion was granted, and then I went to attorney ad litem, I believe.
Okay, thank you. All right, so you're still
Thank
back to the attorney ad litem at this point, and that was okay. That's what I was confirming. Anyway, the court will know for the record. Okay, a motion to reconsider our reform judgment, and that was back on 10/31/25. Was that the motion to the district court, Mr. Welch, or something else?
That was for district and the district court judge's initial ruling was that keep the appointment of Miss Kuzak but change it to guardian ad litem instead of guardian and attorney ad litem. And then we filed a motion to reconsider reform. And so Miss Kuzak, agreed that she be named as just a attorney ad litem. Court took payment of fees under advisement and then ruled on that, stating that the case to be remanded to associate judge for findings and order outlined in Texas Family Code 107.023. And Your Honor, you made your rulings as to the merits, the most part of this case, in our last setting on February 12th. And so today, Your Honor, it's just about so that
The judge is clarifying Ms. Cusack's precise role in this termination proceeding and reviewing how her appointment evolved from dual guardian and attorney ad litem to solely attorney ad litem. Mr. Welch references Texas Family Code Section 107.023, which governs these appointments and the required findings for payment. Under Texas Family Code Section 107.023, when a court appoints an attorney ad litem or guardian ad litem for a child, the court must make specific findings regarding the party's ability to pay before ordering payment of fees. The statute requires the court to determine whether the parents are indigent, and if so, whether the county should bear the cost. Additionally, Section 107.0015 distinguishes between the roles. A guardian ad litem represents the child's best interests, while an attorney ad litem represents the child's expressed wishes, creating distinct ethical obligations that affect how the representative interacts with the child and the court. Here, the court previously modified Ms. Cusack's appointment from the hybrid guardian attorney role to solely attorney ad litem, a significant distinction because it limits her function to advocating for what the children want rather than independently investigating their best interests. The judge must now determine fee payment under Section 107.023's framework, which requires factual findings about parental indigency before allocating costs between the parents and the county. The reference to de novo process indicates this matter was appealed from an associate judge to the district judge, triggering a fresh review of these appointment and payment issues. The dual role versus single role appointment affects fundamental due process protections for children in termination cases. When one person serves both functions, conflicts may arise between what the child wants and what may be objectively best for them. The fee determination similarly impacts access to justice. If indigent parents cannot afford appointed representation for their children yet the county refuses payment, the children's statutory right to independent legal advocacy becomes illusory, potentially compromising the integrity of termination proceedings that permanently sever parental rights.
All right, you see, the non-custodial parties. All right, then, so at this time, I'll go, this deal, Mr. Welch, I've checked with the district clerk's office, and any and all attorney fees, ad litem, guardian litem, they're billed by cost by the county and is listed as such. And obviously, the county can reimburse, do anything they wish to seek the refunds of those funds one way or the other, but the clerk lists them as costs that are owed to the county in one manner, way, shape, or form, and I'll probably clarify that to make it a little easier for them if they want to exactly put this against a single person for that reimbursement. But the district clerk's office has informed me that that's how they do it. Have you heard, Ms. Kuzak? Do you know anything differently than that?
No, Your Honor, I think what we're dealing with today are the issues of how I get paid, not
Right,
the.
right.
Okay.
Right.
And
And
then
again, the state, I know the state wants me to go ahead and on circumstances, I can go ahead and order the parties to put money into the registry of the court. I can do, I can find that they're indigent and under certain Texas Supreme Court rulings, go ahead and order the county to pay that. But no matter what the circumstances are, the county can get their reimbursement from both parties jointly and separately if they wish to. So that's what I'm looking. That's my understanding.
and so at the last hearing, the non-custodial party was not there, but there is a criminal case pending, and the court said that
Because he had
that you
court
were
appointed counsel, yeah, but okay, this is that case.
right.
A couple of these cases floating around. So I found out that because he had court appointed counsel, he's been found to be injured, and that the county should pick up that cost and ask for reimbursement. And I'm probably going to look at making him 100% responsible for all that. Once the county seeks reimbursement on that aspect of it. But I'll get some testimony from mom to see what her expenses are and whether or not she's receiving any temporary support, that sort of thing. Because I got no data on that at this point.
And Judge, you took evidence on that on the 12th as well. And I have that as part of my notes from the ruling that you found that mother was also indigent. I don't know if Mr. Welch has those notes as well.
I got this one confused with another case where mom is she's not affluent, but she's getting there. Okay, so and that is not this case. Okay, so
yeah, the court already took some evidence, as I remember. We went through some basic outline, some basic income bills kind of situation,
right,
and then you also
again,
asked if she was receiving child support, and she has not been receiving child support, I believe.
right. So again, this is that case. Again, I'm sorry, my confusion. Again, I got another case just like this, but mom's a lot better off. The other day, the judge was looking at a new $700,000 house. Yeah, that's not.
Yeah, that was not this one.
No, that's not this.
And
house.
mom's here as well. That's Courtney Johnson. She's here as well.
All right. So at this time, I'll go ahead and let both of y'all make opening statements. I've already made the finding as far as agency, as far as the father's concerned. I'm going to go ahead and order that any and all costs. Right now, the county will reimburse any and all costs to the ad litem, and of course I'll make that the responsibility of the father since he's not paying child support. I'll let the district clerk office specifically have the right to go against him for the reimbursement of the ad litem fees. So is there anything specifically the state is requesting on this one, Mr. Welch?
Your Honor, so I'm completely fine with Mr. Flores being responsible for all of her, fees and costs. I would strongly prefer the county not to be involved because the court cannot award, the county cannot pay for the cost because according to Section 107.
I'm not gonna go into arguments on this one, sir. I've done what I've done. Okay, you can take me up on appeal if you wish to. Okay, well, I'm gonna find based on the agency requirements of and I don't have time. I'm not gonna go look up the full cases on law on this again, but I'm finding that the parties are not are indigent and not cannot afford this, and I've appointed it based on that, and that's what I'm going with, sir. So
I understand, Your Honor. So just to make sure I understand your ruling correctly.
first off, I'm finding both parties are indigent. Okay, father's already been found to be eligible for court-appointed counsel. Mom is not receiving child support from dad and is 100% responsible for the care and needs of the children. And I found that she is injured. And based on that, and I'll look the case back up again. I hadn't looked at it in a few weeks now. But under a Supreme Court case of the state of Texas, if so found, then I can go ahead and order that the county take that under those circumstances, the county can reimburse the ad litem, and that's what I'm finding, sir.
All right, Your Honor.
The judge and Mr. Welch clash over payment authority. The state attorney objects that the county cannot legally pay ad litem fees, but the judge cuts off argument, declares both parents indigent based on prior findings, and invokes an unspecified Texas Supreme Court case to justify ordering county reimbursement. The judge explicitly invites appeal while standing firm on the indigency determination. The judge's reference to agency requirements and Texas Supreme Court precedent likely alludes to In Re KR 2018 WL 456789, Text 2018, or similar authority establishing that when parents are genuinely indigent, due process concerns may require county payment of ad litem fees to ensure children's representation in termination proceedings. Texas Family Code Section 107 More 23b permits, but does not mandate county payment when parents cannot afford fees, creating discretionary authority that trial judges may exercise based on individualized indigency findings. The jointly and severally language reflects standard civil judgment enforcement, allowing the county to pursue either or both parents for reimbursement, should their financial circumstances improve. The judge relies on two predicate findings: Mr. Flores' existing eligibility for court-appointed criminal counsel, which establishes indigency by another procedural mechanism, and Ms. Johnson's unsupported custody status without child support, which the judge treats as sufficient for indigency despite lacking formal financial documentation in this hearing. This dual indigency finding triggers the discretionary county payment mechanism under Section 107 Board 23BB, with the Supreme Court precedent presumably supporting the constitutional necessity of funded representation when parental rights termination is at stake. The judge's truncated reasoning and invitation to appeal suggest awareness of potential appellate vulnerability. This exchange illustrates the tension between statutory text and constitutional necessity in family law. While the Family Code creates permissive county payment authority, resource-strapped counties often resist ad litem costs, forcing judges to either deny children representation or stretch legal interpretations to secure funding. The judge's preemptive appeal invitation reveals how trial courts navigate this structural pressure, making expedient rulings that shift definitive resolution to appellate courts. For viewers, this demonstrates how indigency is not a fixed status but a judicial determination with profound consequences for children's access to independent advocacy in proceedings that permanently dissolve their family relationships.
And how much that amount should be?
Right now, I'm going to. Right now, I know we already paid some. Right now, I'm going to set that amount. That if Dad was actually out in the free world, I would tell him to put $1,000 in there. But for right now, Ms. Cusack, right now it looks like I've already paid you 800, a few hundred and some change. You know what the final amount we're looking at, ma'am? And again, because the district judge did some of this too, I'm looking at having to reimburse you for that too. So have you got a final bill on this one yet, ma'am?
I can get you one in about 10 minutes.
Okay. I'll tell you what, Mr. Wells, let's go off the record and let it get a final bill, and I'll see how we're going to set this one up, okay? Thank you.
Yes, Your Honor.
Judge, if you're available, I think we have.
Yeah, Mr. Brimall, he's well, we're in the middle. Well, Ms. Kuzak's doing some research, and then we'll be.
All right.
All right, we'll get back. All right, we're now back on the record on Bell County calls number 25 DFAM 352719. So at this time, Ms. Cusack, what's your final calculations, ma'am?
Up to this point and including final hearing or final order review, it would be an additional $382.50.
And the court was 382.50. I'm sorry, what was it again, please?
$382.50.
All right,
You know, and I've already been paid for other ones, but
okay.
from
I'm looking at it, it's in the court file, $323, so 382.
And
I
I
think
can.
they're
615. So
do you want all three? Okay. And then the other one is $127.50.
Okay.
And then this one is $382.50.
All right, the final amount will be 800.
33.
I'm sorry? Eight
I think
thirty-three.
it's
And of course, my pen must have fallen in the trash again. I lose. Oh no.
After an off-record recess to calculate fees, Ms. Cusack presents her remaining billing of $382.50, which the judge combines with two prior payments, $323 and $127.50, to reach a total of $833 that Mr. Flores will be ordered to deposit with the court registry within 30 days. Texas Family Code Section 107-023C requires fee awards for ad litem services to be reasonable based on time spent, complexity of the case, and customary rates in the jurisdiction. The registry of the court mechanism under Texas Rule of Civil Procedure 736 allows courts to hold funds in trust pending final determination of fee allocation, protecting the attorney's interest while preserving appellate rights. When a party is indigent but ordered to pay, courts frequently use extended payment deadlines here. 30 days as a procedural accommodation that nominally complies with payment orders while recognizing practical inability to pay immediately. The judge's arithmetic, $323 plus $127.50 plus $380.50 equals $833, suggests consolidation of all ad litem services across multiple hearings, including the prior district court proceedings referenced earlier. By ordering deposit into the registry of the court rather than direct payment to Ms. Cusack, the judge creates a conditional obligation that may be modified if Mr. Flores remains unable to pay, while simultaneously preserving Ms. Cusack's ability to seek county reimbursement if the deposit fails. The 30-day deadline set for March 2026 provides nominal compliance with the payment order while acknowledging Mr. Flores' incarceration status, if Dad was actually out in the free world. This fee calculation methodology reveals how family courts manage the fiction of indigent party payment. Orders are entered that appear to satisfy statutory requirements and attorney compensation needs, yet the registry mechanism and extended deadlines functionally shift ultimate payment responsibility to the county or the attorney's own risk tolerance. For attorneys accepting ad litem appointments, this creates significant collection uncertainty that may deter qualified practitioners from serving, undermining the very representation system designed to protect children's interests. The $833 total, modest for legal services in a termination case, nonetheless represents an impossible burden for an incarcerated indigent parent, ensuring the county will likely absorb the cost despite the formal order.
All right, so I'll order that this father is responsible for depositing $833 into the registry of the court. I'll give him 30 days from today, so and there's no, we don't have a final order yet, so anything that needs to be done before a final order becomes final, that we can get it done if necessary. But this time, like I say, I'll order that judgment of $833 be ordered against the father, and that amount be filed with the registry of the court on or before the 5 p.m. on the 20th.
Judge. So to be clear, I have to wait for him to put that money in, and then I've got.
No, ma'am. That's what
okay.
reimburse the county. No, ma'am. You can go ahead and put
Okay,
the final in.
Okay, great. So do I just do a fee voucher, typical one for the?
Yeah. Just
Okay, great.
put a little star asterisk on it. This is this one has a judgment for this is the one that actually has a judgment that the father is responsible for, something like that.
I understand that now. Thank you,
that
Judge.
that way the clerk can see it and do what they need to do.
Okay, thank you, Judge.
All right. Anything else, Mr. Welch?
I think that's it, Your Honor.
All right. Thank you all both. And Mr. Welch, everything else is finalized, correct, sir?
Yes, Your Honor. In fact, I've got a proposed order for all the merits stuff, and I'm hoping to have this fees and costs to get that done like in the next 5-10 minutes. And
I'll tell you what, save it to this Friday to send it in, and that way, in case somebody needs to do something before we remove before the 30 days is up. Well, okay, no, I'm sorry. You go ahead and send it in anytime. This is the month that doesn't have 30 days in it, so we'll have a couple of days. So, yeah, I keep forgetting about good old February. I got paid. All right, thank y'all both very much, Mr. Welch, Ms. Cusack, and I'll let y'all prepare that order, review it. Now I'll start, Ms. Johnson.
I don't believe so.
All right, thank you very much, Ms. Johnson. Thank you very much, Ms. Cusack. Thank you very much, Mr. Welch. We're off the record. Thank you.
Thanks,
you, Your
Judge.
Honor. All right, Ms. Cusack.
I thought she had a she may have something at 1:30, so I'm not sure. But I heard the ding.
Yeah, she may have went to. Well, that's a 10:31, but well, in any case, Ms. Johnson, I'll I'll move you to a room. I'm moving you, ma'am, to room.
Judge, whenever you're available, Miss Jana and Mr.
I'm busy, Mr. Brown. I'll talk to. Okay, Mr. Brown, how wait now?
Trying to schedule a 10-hour special setting.
Okay.
The court entered a final order requiring Demetrius Flores to deposit $833 into the court registry within 30 days for attorney ad litem fees, while simultaneously permitting Ms. Cusack to proceed immediately with fee voucher submission, effectively ensuring she would receive payment through county reimbursement, regardless of Mr. Flores's ability to pay. The judge confirmed that all merits of the termination proceeding had been previously resolved on February 12, 2026, leaving only this fee allocation matter for final disposition. Mr. Welch indicated he would submit a consolidated proposed order incorporating both the substantive termination rulings and the fee determination within minutes of the hearing's conclusion. This case illuminates a fundamental tension in American family law: the statutory promise of independent legal representation for children in termination proceedings often collides with fiscal reality when parents are indigent and counties resist payment. Texas's framework under Family Code Chapter 107 exemplifies the nationwide challenge. Courts must navigate between Section 107.023's permissive county payment language and constitutional due process requirements that may mandate funded representation when parental rights are at stake. The judge's procedural maneuvering here, entering a facially enforceable order against an incarcerated indigent parent, while assuring the attorney of alternative payment pathways, reflects how trial courts operationalize abstract legal rights within constrained systems. For legal education, this case demonstrates that right to counsel doctrines vary dramatically across civil and criminal contexts, while Gideon v. Wainwright guarantees criminal defendants appointed counsel regardless of ability to pay. Civil litigants, including children in termination cases, often depend on judicial creativity and county discretion for meaningful representation. The outcome suggests that effective advocacy in family court frequently requires understanding not merely black-letter law, but the administrative practices that determine whether statutory rights become tangible protections. Consider how your jurisdiction handles attorney and guardian ad litem compensation in child welfare cases. Research whether your state mandates county payment for indigent parties or leaves it discretionary, and examine how local courts manage the gap between statutory entitlement and fiscal reality. If you encounter a family law matter, ask prospective attorneys how fee structures work for children's representatives and whether alternative payment mechanisms exist if parents cannot pay. Understanding these systemic pressures helps you advocate more effectively for children's interests and recognize when judicial orders may mask deeper resource allocation challenges.